Jaden Larry, and this is case number 23C4199. And we're here today on the sentencing. The jury has returned a verdict of guilty as charged of robbery and failed to make any special findings. Is that correct? The state and defense ready to proceed to sentencing?
Judge, one of the issues when the verdict was returned was whether it was a true verdict because there was no special findings. Based upon the research that I was able to locate, and I think Mr. Sullivan came with the same case law that I did. It stands for the lowest robbery, so we did look at that. So I think he's to be sentenced on a simple robbery, which is a second-degree felony.
There was no enhancements filed. No, it was.
I did, Your Honor. I did file a notice to seek the violent habitual felony offender. I'm not going to be doing it this time based on the case law earlier. There's some dispute about whether there needs to be a jury finding of those things or not. So, out of an abundance of caution, I will not be proceeding forward on that.
All right. And prior to coming to court today, I reviewed some couple letters in support of Mr. Larry. I think they were, I don't know if they're in the court. I know there's some correspondence in the court file, but they were provided to my office.
Is it from his
from one employer I know, and one that of maybe a
All right, guys, this one's intense. Case number 234199. The courtroom's packed tension high. Jaden Larry standing before the judge as the verdict drops. Guilty of robbery. No special findings, just the cold slam of a felony label. Defense scrambles to pivot. They want simple robbery on the table, second-degree felony, no enhancements. But this ain't some soft walk. The state's lurking, and they got history in their pocket. They wanted violent habitual offender status. Didn't get it, but don't think for a second they're letting this one slide easy.
Some sort of after school or...
While Mr. Sullivan's reviewing that, there was also some family photos that Ms. Rolak provided, if the court would like to see those.
Okay. I've reviewed the letters. I reviewed the letter from Ms. Rolak. I reviewed the pictures. And Mr. Meredith, anything that you and Mr. Larry would like to put on the record prior to sentencing?
Yes, as far as what you've received is basically kind of a slanted PSI towards us. So if PSI was necessary, I think you've received that information that you would have. So he has never been sentenced to Department of Corrections. So if PSI is required, I think you've got
what I would get from a PSI. So
yes.
You're willing to waive that at this time?
Yes, sir. And I believe Mr. Larry did want to put some things on the record and address the court.
All right. Go ahead, Mr. Larry.
I don't want to take too much of your time up. You feel me? I know you got a busy day, but you know, as the process been, a lot of things happened during the process. You know, with first jury selection and stuff like that, it turned into a Richardson hearing because of a lot of evidence that wasn't presented 5 months ago after we asked for it prior up to that date. And, you know, the Williams Rule hearing came after that, and, you know.
Before sentencing hits, the court flips through letters and photos, a desperate plea of character. Employers speak, family supports, judge listens. But let's be real, sympathy only goes so far when you're up against a guilty verdict. Defense starts talking PSI. That's pre-sentence investigation, but says the court already has the facts. Jaden's never done time in DOC. His team's hoping that history plays soft, but this is still a felony conviction staring back at him, and the judge is watching every word. Then it's time for the man himself to speak.
Things were said. I think everybody could conclude that they couldn't, nobody said it was me. He couldn't identify me as a person, and there was no physical evidence in none of these cases, but a pair of alleged slides I was involved. And the day of the trial, more evidence came up that I didn't never see, my attorney never saw. It's clearly a discovery violation, Brady violation, however you want to call it. But, you know, I know everybody's doing the best of their ability to make sure everything gets seen and viewed. You feel me? And I appreciate my attorney for everything he did at trial, Miss Beasley, and as well as Mr. Sutherland. He's just doing his job. You feel me? But a lot of things with the witnesses, I was expecting one to be here. She didn't show up, but I guess she got denoted or whatever. I didn't know all this to the last minute, but even at trial with the detectives saying they couldn't ping my phone, and they did ping my phone. They had a search warrant for all of this. They did a tower dump, stage 1 and stage 2. I was never in the location. So it was just a lot of stuff that was said at trial that was actually false. And you feel me, about the hitting licks thing. I was never talking about licks. My girlfriend's name is Lex. That's probably why he said what he said. Oh, I didn't know. That's what it sounded like. I never said that. I never gave any admissions or any involvement or any knowledge of the crime that was being committed. So
Jaden Larry steps up. And now it's personal. You feel me? He says, a man trying to be heard, raw and frustrated. He calls out holes in the process, missing evidence, last-minute surprises, false IDs, and what he claims are Brady violations. No one could ID him. No prints. No phone pings. He says it plain. They got the wrong guy. His girl's name is Lex, not Licks. Even witness testimony, weak, confused, and one witness didn't even show up. Jaden's pouring it out, not just for a lighter sentence, but to be understood.
in the process of all this happened, a lot of stuff that I didn't agree on, a lot of stuff that I felt should have been ejected on, even the speculations of the robber hopping into the vehicle that was never seen, never happened. And it was just a lot of stuff. But, Your Honor, I appreciate everything Mr. Meredith did. You know, I appreciate everything Mr. Beasley did. You know, everybody just doing their job. You do what you do to the best of your ability to be fair and impartial. And I want to thank my mom and my girl for being here as well. And everybody else.
Mr. Meredith?
I respect the jury's verdict because they sat through it, but I do respectfully disagree with their finding. As Mr. Larry pointed out, you are familiar a little more deeply than the jury was because of the Williams rule hearing and then hearing the testimony at trial. Mr. Larry made no admissions. The DNA on the slide was a mixture. There was never an identification of Mr. Larry as being the person that robbed the Dollar General October 18th.
Hold it down just a little bit, okay?
To my mind, there was more than reasonable doubt. There's another time for dealing with that. The state has shown me a score sheet which appears correct, where the lowest permissible sentence is 25.5 months.
And here's where it hits hard. His defense steps in, breaking down everything the jury missed. No confession, mixed DNA, no direct ID. Reasonable doubt? Absolutely. But that doubt didn't sway the verdict. The state's score sheet drops, lowest sentence, 25.5 months. But the state? They're pushing max 15 years. Why? Jaden's got priors. Carjacking. Was already on probation. The prosecution drops the hammer. This isn't a one-time mistake. This is a pattern. They call it out plain. No remorse, no growth. And now they want time, real time.
Based on the facts and circumstances that you heard throughout this case at various hearings and in trial, I'd ask for the lowest permissible sentence with no probation to follow. He has 464 days credit against this.
State?
Your Honor, while typically a court cannot consider lack of remorse at sentencing, the case law is clear that if the defendant testifies at trial or voluntarily testifies during the sentencing hearing, the court then can consider the voluntary statements that were made and the lack of remorse at that time. So I'm asking the court to consider Mr. Larry's lack of remorse based on his statements here today. Additionally, based on Mr. Larry's score sheet, as you can see, he's got a prior violent felony for carjacking. This is not his first violent offense. In fact, he was actually on probation for that carjacking offense at the time. So I'm asking for a harsh sentence in this case, Your Honor. Mr. Larry is not a first-time violent offender. He was given a chance the first time he was sentenced on that carjacking. Did not take anything from that. So I'm asking for the maximum 15 years in this case, Your Honor.
All right, at this time, Mr. Larry, a jury of your peers has found you guilty of strong-arm robbery. It is my obligation now to sentence you as follows. You'll be adjudicated guilty of robbery, sentenced to 15 years in the Florida Department of Corrections. Given credit for how many days? 464 days time served. I am going to set restitution amount of $600 to Dollar General. That's reduced to a civil judgment. Your assessed fines and costs of $1,028. Those include discretionary costs of $2 of local law enforcement education, a $65 assessment of additional court cost, a $150 discretionary public defender fee payment, and a $200 discretionary fine. The fines and costs are reduced to a civil judgment.
The gavel's ready. The judge looks at Jaden and delivers the blow. 15 years in the Florida Department of Corrections. That's it. No probation, just hard time. He gets credit. 464 days already served. Restitution? $600 to Dollar General. All of it becomes civil judgment. No wiggle room. Fines, fees, court costs, stacked. It's a full sentencing package and the court isn't blinking. This wasn't just a trial, it was a turning point. The justice system heard his words, weighed the evidence, and brought the hammer down hard.
Of course, since it's a 15-year sentence, there's no probation to follow. All the fines and costs and restitution are reduced to a civil judgment. Mr. Larry, you have 30 days to file your notice of appeal. If you wish to appeal this judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir.
Two other things real quick. The restitution amount, the $600, that was something that Mr. Meredith and I spoke about. There was some conflicting numbers about the exact amount that was taken. I suggested the lowest amount so that's where that 600 came from. I believe that's been agreed to, and that's why that was submitted.
Mr. Meredith?
As a civil judgment, it's
And the other thing, Your Honor, the state at this time would consolidate the other three cases that Mr. Larry has.
He's released from whatever bonds are on those, and those have been consolidated.
he has family locally. If you'd like to be held in Bay CI, if possible. Or,
It doesn't. I guess.
I just recommend the Florida Department of Corrections house Mr. Larry closest to Bay County.
But can you put on record that you?
yeah, I had spoken with Mr. Larry last week that he didn't even have to ask me. I was going to have the appeal prepared, and it would be filed by the end of next week.
Mr. Meredith will file the notice of appeal, then the Second Circuit Public Defender's Office will handle the appeal over in Tallahassee. Okay?
But I'll get the record perfected and get everything up there. All right.
All right. You need to step over and be fingerprinted.
But it's not over yet. There's still movement behind the scenes. The appeal? Already in motion. Lawyers are prepping. Records are getting filed. Mr. Larry might be in chains, but the fight's not done. The court's wrapping up, talking bond releases, consolidation of cases. But the biggest thing, this isn't just a courtroom drama. It's real life. Family, futures, justice, and pain all crashing together. And whether Jaden walks free one day or not, this case is a brutal reminder that the system hits hard and fast. You better be ready when it does.